introduce him again. Professor Jan Krijns is a professor of criminal law and criminal procedure at the Institute for Criminal Law and Criminology. He is also the head of the department and also the adjunct judge in the Haarlem, if not.
In the Court of Appeal, I was a judge in Haarlem in the district court, and now I'm a judge in the Court of Appeal in The Hague.
Okay, he's judge in the Court of the Appeal in The Hague. We call it in here, it's Pengadilan Tinggi. Court of the Appeal is Pengadilan Tinggi in The Hague. And then he is he was my supervisor for my PhD research. And then on the public prosecutor in Indonesia. And he will deliver on the second lectures on the role of the prosecutor as the dominus litis. I think this is the important topic for us because we want to revise our criminal procedure, Indonesian Code of the Criminal Procedure, and also we just revised the public prosecutor's law last year. So without further ado, please, Prof. Jan Krijns to deliver the lectures. The time is yours.
Thank you very much, Professor. Thank you very much for your kind introduction and for having me. It's a big honor and a pleasure to deliver this second lecture to you. I shared my screen, so I hope you can see the presentation. Yes, okay, that's great. Well, last week I gave a brief introduction to the Dutch criminal justice system, and now we are moving on in the second lecture with the role of the prosecutor as the dominus litis, an important subject for Dutch criminal procedure because the prosecutor really is dominus litis in the Netherlands. He's definitely the most important person in all phases of the criminal proceedings, except for, of course, the accused. Of course, it's in the end about him. But when it comes to the separation of powers between the authorities within the criminal justice system, the prosecutor definitely is the most important one. So that is what we are going to discuss today, and we have three subjects which we have to discuss today. First is quite general. What is the position? What are the tasks of the public prosecutor? And then we will see that it's mainly the prosecutor as the head of the investigation, and the prosecutor as the one who is responsible for the prosecution and for the prosecutorial decisions that can be made in Dutch criminal procedure. And as we will see, there are several options for the public prosecutor to handle a case. It's not just going to trial, but outside that option, he has several other options like case dismissal, penal orders, etc. So that is what I will show to you today. And of course, like last week, if there's of course room for a Q&A at the end of the lecture, but if you have questions during my lecture, feel free to ask them, then I will try to do that. All right, the position of the public prosecutor. I already told you a bit about this last week. The public prosecution service in the Netherlands has a kind of a split position. Partly, it's part of the judiciary, like the courts, and the position of the public prosecutor is also in the WetRO, the Act on the Judiciary, and that means that for a part we consider the prosecutor to be part of the judiciary, which means that he has to act as independent and impartial as possible, but he is not as independent as a judge is, as the courts are, because in the end, he is working under the responsibility of the Minister of Justice as well. So for one part, the prosecutor is part of the judiciary, but for another part, you can consider the prosecutor as a part of the executive. So that's kind of a split position, and what does that mean in practice? In practice, this does mean that he's under the he's working under the responsibility and under the guidelines of the Board of Procurators General, the head of the Public Prosecution Service, which is working on the responsibility of the Minister of Justice. So when it comes to the general policy of the Public Prosecution Service, there are definitely guidelines that are binding to the public, to the individual prosecutor. But when it comes to individual cases, then we would like the prosecutor to act as independent and impartial as possible. So there is a possibility for the Board of Procurators General to intervene in individual cases, but we don't like that too much. We are quite hesitative to do that. So when it comes to individual cases, the prosecutor really is dominus litis of the case, and he is the one who takes decisions, and he is the one who has to take his decisions like a magistrate. We would like to consider the prosecutor as a magistrate when it comes to individual cases. So he has to balance the interest of of law enforcement against the interest of the accused. So the interests of the accused are important for him as well. So that is a kind of split position for the public prosecutor, but it is important to Dutch criminal justice because the prosecutor has a lot of powers in the Dutch criminal justice system, but it's important that he deliver his tasks as impartial and independent as possible. But again, in the end, he is under the responsibility of the Board of Procurators General and the Minister of Justice. That he is part of the judiciary, we can also see in Article 124 of the Wet RO, the Wet op de Rechterlijke Organisatie, the Act on the Judiciary. There we see that the Public Prosecution Service is responsible for criminal law enforcement. So that is a broad task, of course. What is criminal law enforcement? It can be divided in several tasks, and when we have a look at the Code of Criminal Procedure, then we see that the prosecutor is responsible. It's mainly responsible for two tasks. He is responsible for the investigation, and he is responsible for the prosecution. Both very important and broad tasks, and of course the prosecutor is not the only one who has to conduct this task, especially not when it comes to the investigation. In practice, the investigation, of course, is mostly carried out by the police and other police organizations. Of course, we have the national police for normal policing, I would say, but we also have several special investigation services, for instance, for tax crimes or other financial economic crimes. And of course, the police and these special investigation services are the most important when it comes to concrete acts of investigation. Of course, when someone is arrested by the police, not by the prosecutor. And of course, when it comes to other investigation tasks, they are mainly carried out by the police. But in the end, the prosecutor is responsible in all cases, as we will see. And the second main task, which we will discuss today, is the prosecution. We have the vervolgingsmonopoly in the Netherlands, which means that he has a monopoly on prosecution. The public prosecutor is the only one in the Netherlands who can prosecute criminal cases. So not the victim, not other governmental authorities, only the public prosecution service is entitled to start prosecution. And he's also the only one who can take prosecutorial decisions. And as we will see later on this morning, this decision is governed by the principle of discretionary powers, the opportunity principle, het opportuniteitsbeginsel. And this principle means that the prosecutor is not obliged to start prosecution. He doesn't have to. He is also, or he may also dismiss the case or handle the case outside the court, for instance, by a settlement with the accused. So there are several options for the prosecutor to deal with criminal cases, and the options that are available to the prosecutor, I will discuss these later on this morning. Is it clear for now? If there are any questions, please feel free to ask. Of course, Vagisal already knows all of this because he discussed it many times here in the Netherlands. Okay, when we have a closer look to the investigation phase, then again, we see that the prosecutor is head of the investigation. And of course, the question is, what does this actually mean in practice? You can be head of the investigation, but does that mean that you're always there when the police is investigated? Of course, the answer is no. De jure, in law, legally, he always is head of the investigation, but in practice, of course, most of the investigation is done by the police themselves, and it depends on the seriousness of the case, how much involved the prosecutor is. Of course, when it comes to minor offenses, to petty crimes, then the prosecutor he still is head of the investigation, but that only means that he is responsible for the investigation. But when it comes to more serious cases, for instance, murder or manslaughter, then a big investigation will start, and then the prosecutor really will act as head of the investigation. Then he will give orders to the police, then he will think of the strategy of the investigation, and then he really is also in practice head of the investigation. So it depends on the seriousness of the case how this works out in practice. What is also important is that some investigation powers can be used by the police without further authorization of the prosecutor or whatsoever. But when it comes to more serious investigation powers, then the prosecutor has to order them, then the prosecutor is the only one who can really deploy these investigation powers, and sometimes only after authorization of the examining judge. So the most serious investigation powers are only available upon authorization of the examining judge. Well, another important rule is that the police and all the other special investigation services must send their police reports to the prosecutor, and all these police reports together will form the case file for the prosecutor and maybe later on for the courts. So how does the prosecutor know what the police is doing in all those investigations? Well, by the police reports, which are sent in by the investigation authorities. And that means that he is, and that's maybe most important, the prosecutor can always be held accountable for the lawfulness of the investigation. He must, well, he's responsible that the police is conducting the investigation legally, and if the police deliberately or by accident violates a criminal procedure, well, then can there be consequences, but not so much for the police themselves, but for the prosecution of the case. And then, of course, it depends on the seriousness of the violations made by the police. If they're not that serious, then the judge later on, when it comes to trial, then the judge will only assess there was a violation and say, well, this is, of course, it was illegally, but there are no consequences. But if the violation is more serious, for instance, a violation of the right to privacy during the investigation, then there can also be procedural sanctions, which are embedded in Article 359A of our code. And one of these sanctions is sentence reduction. So a violation of the rights of the accused in the investigation phase can or may lead to sentence reduction later on in the trial. But it can also lead to exclusion of evidence. When evidence is illegally obtained and seriously illegally is obtained, then the judge may also exclude the evidence which is resulted by the illegal acts of the police. And in very serious cases, but that happens very few in the Netherlands, there can also be a stay of proceedings, which means that the criminal trial, will end. There is no right to, there is no fair trial possible anymore, and because there's no fair trial possible anymore, the judge will say, okay, we'll leave it here. I will deliver the stay of proceedings. Het niet ontvankelijkheid in Dutch. But that happens only a few times per year, and we are quite reluctant with these procedural sanctions. So it's good that they are there, but of course, we also, especially the Dutch Supreme Court, is also of the opinion that crime has to be combated, and crime control is an important goal of criminal procedure, and of course due process is as well. But when there are violations of human rights, there can be sanctions, but not every illegal act of the police will lead to exclusion of evidence or a stay of proceedings. So it's a balancing act between the interests of crime control and due process. Okay, that's for the investigation phase. Then I come to the prosecution phase. After completing the investigation, the prosecutor, of course, has to take his decision on prosecution. What are we going to do with the case? Is it an important case? Is it not an important case? Is it a strong case? Is it a weak case? It's all relevant for his prosecution decision. And of course, when it's a weak case, which with weak evidence and a big chance the accused will be acquitted. Well, of course, the prosecutor is not obliged to go to court with those weak cases. So, of course, he can dismiss weak cases with a lack of evidence. But and he can also drop cases when there are other reasons why going to trial won't be successful. For instance, the accused already died, or the accused is too young, or the case is expired. Those are all reasons to dismiss a case before going to trial. But important for today is that we also have the principle of discretionary powers, the opportunity principle, opportuniteit. And this means the legal basis in Article 176 and 242, or 67, I must say. What is important is that the prosecutor is not obliged to start prosecution. He doesn't have to. He does not have to. Also in cases which are, from an evidentiary perspective, strong, he's not obliged to start prosecution. He may also choose to dismiss or to divert a case because of reasons of public interest. And that is the principle of discretionary powers. To decide to not go to court because of reasons of public interest. And that is what we call opportuniteit. We want prosecution to be useful. We want that there is a strong and good reason to go to court with a certain criminal case. And of course, you can be of the opinion that prosecution is always in the public interest, but actually that depends on the case. When it comes to a minor offense, then it can be doubted if going to trials in the public interest, or when the victim is already compensated by the accused. Is there really a public interest to go to court? Well, we give the prosecutor the room to say, well, in some cases, it is better to not go to court than bring the case to court for a full trial. So the prosecutor has to take a decision on the opportunity of prosecution. But that also leaves, and that is, well, no, I will say it differently. When you have a look at the principle of discretionary powers, you can get the it may suggest that the prosecutor in every individual case will assess, is this case a good case to go to trial, or are there reasons for not going to trial? So then it's a really individual decision by every single public prosecutor. Well, to a certain extent, this is true, but maybe more important is that the principle of discretionary powers also gives a legal basis for developing policy guidelines on prosecution. We have in the Netherlands many policy guidelines on prosecution, and every citizen of the Netherlands can read these policy guidelines, and you can, to a certain extent, predict whether the prosecutor will go to court with your case, or if the prosecutor will dismiss your case or give you another sanction. So we have a lot of guidelines, and it depends on the seriousness of the case, and of course of the person of the accused, whether he will go to trial or not. So we have for several crimes these guidelines: for theft, for violent crimes, for every single type of crime, especially for minor crimes, of course. We don't have policy guidelines for manslaughter, etc. Of course, we will bring those cases to court. That is without discussion. Okay, let's move on if this is clear to you. Since we have this principle of discretionary powers, the prosecutor has several options which he can choose when he has completed the investigation. The first one, of course, is bring the case to trial. So make an indictment and send the accused to trial. Of course, there's always an option. But it is a heavy option. It is also an expensive option. So in minor crimes, other options are attractive as well. He can dismiss the case. So just drop the case, say, thank you very much, police. Thank you for the investigation, but we leave it to this. We will drop the case. It can be of technical reasons because you have a lack of evidence or the case has expired, but it can also be of opportunity principles, as I told you before. And an unconditional dismissal means that it's a definite decision without conditions to the accused. There's no sanction, there's no reaction from the public prosecution service. It's just we leave it to this. Now, of course, that is not a very strong reaction to crime. This in most cases, there will be, of course, some kind of sanction. And then one of the options is a conditional dismissal. And the conditional dismissal means that it's kind of a quid pro quo. It's kind of an agreement with the accused. In case of a conditional dismissal, the prosecutor will say to the accused, well, I can bring this case to court, but I'm willing to dismiss the case and not go to court, but only under certain conditions. And one of these conditions, for instance, is that you don't commit crime anymore for the next year or the next 2 years. And if you can show me that you you're not committing crime anymore the coming years, then in 2 years I will take the decision to dismiss the case. So then there is a kind of a condition to the accused, a condition on his behavior. It can also be other kind of conditions. For instance, you have to compensate the victim, and if you compensate the victim, if you pay the compensation, then I'm willing to dismiss the case. So it's kind of an agreement, and when the accused say, well, that's actually a quite good idea, I don't want to go to trial, so yes, I will compensate the victim, and yes, I won't commit crime anymore, especially not for the coming year and the coming 2 years. Okay, I will meet your conditions, and then when he actually does, then in a few years later, the prosecutor will dismiss the case definitely. Actually, this does resemble the extrajudicial settlement, the diversion, or in Dutch, the transactie. Because when it comes to the transactie, the fourth options on this slide, the legal construction is actually the same as with conditional dismissal. Because when it comes to this transactie, this diversion, then the prosecutor will also say, well, I can drop the case, but only if you pay a fine, or only when you're willing to have a community sanction. And then we also have the penal order, which I will talk about later on. But first, another slide on the transaction. Here is this transactie. The construction is the same as with the conditional dismissal. It's based on a consensus, on agreement between the prosecutor and the accused. The prosecutor say, well, I'm willing to dismiss the case, but only if you will meet my conditions, and one of the conditions is paying a fine, or to deliver a community sanction. It cannot be imprisonment. That is important. You cannot agree with the accused to say, well, if you go to jail for a few years, I will dismiss the case. Of course, that is not possible. Going to jail, as we will see, is only possible in a trial, and can only be sentenced by the court. So when it comes to the transaction for an extrajudicial settlement between the prosecutor and the accused, then it can only be fines or community sanctions. And this is not an option in all criminal cases. It's only an option in cases of crimes that are threatened by a maximum sentence of 6 years imprisonment. So that does not mean that you can give this 6 years imprisonment. That is only possible by the court. But you can also enter such a kind of an agreement in cases of crimes that are legally threatened in the criminal code by a maximum sentence of 6 years. So these are misdemeanors, but also crimes, but not very serious crimes. But still, it can consider some violent crimes. It can also, it can be applied by some violent crimes. It can also be applied by theft and traffic crimes, etc. So a lot of crimes can be dealt with by means of a transaction. And what is important, I already told you, it's kind of an agreement, and that means that it's no declaration of guilt. So it's not that the accused is declared guilty by the prosecutor, because it's just an agreement to dismiss the case under certain conditions. So it's not a declaration of guilt, and the conditions are no actual sanctions. It's not an imposition of sanction, because you cannot sanction someone before there's a declaration of guilt. So without a declaration of guilt, there can also not be a sanction. So pure theoretically, you must say it's a condition to dismiss the case, and it's not the declaration of guilt or an imposition of sanction. And that is important for the difference with the other final option, and that is the penal order, de strafbeschikking. The penal order is in its effect quite the same as a transactie, because it's an out-of-court way of dealing with crimes. You don't have to go to trial, so it's an effective and efficient means of dealing with crime. But here, it is not an agreement. A penal order is a unilateral declaration of guilt by the prosecutor. When it comes to a penal order, the prosecutor will say to the accused, well, I read the case file and you're guilty. When I see this case file, there's enough evidence you're guilty. And because you're guilty, I will give you a sanction. So the legal construction is different from the legal construction of the transactie. That is an agreement. That is, well, dealing, it resembles a bit plea bargaining. It is an agreement based on consensus. When we're talking about the penal order, then it's not an agreement, then it's just a unilateral declaration of guilt by the prosecutor. And from a perspective of the trias politica, well, you can ask some questions, I think, because who is responsible for questions of guilt? Well, until we had this penal order, we were used to say, well, that's the judge. The judge, of course, is the one who declares guilt, not the prosecutor. The prosecutor is for prosecution, and it's the judge who's responsible for the question of guilt and for the question of sanction. Well, that is not anymore the case in Dutch criminal justice. For almost 15 years now, we have this penal order, and it is in some way the new way of dealing with minor crimes. So the transactie, which we discussed before, this one, well, it still exists, but its successor actually is this penal order. This penal order is the main instrument for the prosecutor to deal with minor crimes. So it's a unilateral declaration of guilt. The crimes that can be dealt with by a penal order are the same as the crimes that can be dealt with by the transactie. So only crimes that are threatened by a maximum sentence of 6 years imprisonment, and the sanctions that can be imposed by the prosecutor are again paying a fine, a community sanction, compensation of the victim, behavioral conditions. So all kind of sanctions can be imposed by the prosecutor. The only sanction which cannot be imposed by the public prosecutor is, of course, the sanction of imprisonment. That is still upon the judge to deliver. So when the case is that serious that the prosecutor is saying, well, this case really has to be dealt with a sanction of imprisonment, well, then he has to go to court. But we, of course, have Article 6. Article 6 of the European Convention on Human Rights, the right to a fair trial. And that means that no one in the Netherlands, no one in Europe can be held off the court, everyone has the right to access to a trial. So if the prosecutor will give you such a penal order, then there's always an option to appeal against the penal order and say, well, I do not agree with this penal order. I will go to court. I'm going to appeal. But that is a decision of the accused, and the accused has to take this decision within a certain time frame, within 2 weeks. And when he is not appealing within 2 weeks, then the penal order will become definite, and then he really has to deliver the sanction, so pay the fine or and deliver the community sanction. So yes, everyone in the Netherlands can go to court, but when you have a penal order first, then it's up to the accused to appeal to the penal order, and then only when he does this within those 2 weeks, then he will see the judge in court. So these are all kinds of extrajudicial instruments of dealing with crime. So when I go back to this slide, of course we can also we can always go to trial, but there are several options for the prosecutor, especially when it concerns minor crimes, to handle the case by himself. An unconditional dismissal, conditional dismissal, the transactie, the penal order. So all kinds of options for the prosecutor. And this means that when it comes to crimes in the Netherlands, more than the half of the crimes are dealt with by the prosecutor himself, and only the other half of the crimes, so the other 50%, will go to trial. So these are really important instruments for the public prosecutor. But there's also, and that is what I'm going to end with, a new development in the Netherlands, and that is the procedural agreement. When the prosecutor has decided to go to trial, then of course the case is in hands of the court. And then the court will decide on the case. He will take a decision on guilt, and he will impose a sanction when the accused actually is guilty. But what we see the last year in the Netherlands is that the prosecutor and the accused are entering agreements in the trial phase as well. And that is new for the Netherlands. And this has a certain resemblance, it resembles a bit plea bargaining. It is not plea bargaining actually, because the accused does not have to confess the crime, because most procedural agreements are meant to shorten the trial phase. So it's not on a confession by the accused in exchange of a milder sentence, but it's mostly giving up the exercise of certain defense rights in exchange of a milder sentence. I told you last week that criminal trial in the Netherlands is quite efficient in terms of hearing witnesses during trial. Most of the investigation is done in the pre-trial phase, and in the trial phase, well, mostly it's discussing the case file, what is the opinion of the defendant, what is the opinion of the prosecutor, and then we can handle a trial quite efficiently in the Netherlands. But in bigger cases, of course, the defense will exercise his defense rights. So then they will ask for a lot of witnesses, for a lot of extra investigation, and well, that can lengthen trial seriously. And that is not in the advantage of the prosecutor, because the prosecutor always has an interest in efficient dealing with crime, to efficient deal with crime. So then he will try, or what we see the last year is that the prosecutor is trying to enter an agreement with the accused. And then he will say, well, when you give up your defense rights, I will ask to the judge for a milder sentence. So the goal of these procedural agreements is speeding up the trial in difficult or lengthy cases. The trial judge has its own responsibility for the outcome of the case. So the trial judge always has to ask himself, well, I'm not a party in the agreement. It's an agreement between the prosecutor and the accused, but I will go with the agreement, or I will quash this agreement. So the trial judge may always is always entitled to say, well, I'm not bound to this agreement, so I will start a full trial. But he can also say, well, it's a good agreement, so there's no reason for a full trial. I will decide accordingly to the agreement, so a milder sentence and declaration of guilt of the accused. This is a quite new development in the Netherlands, and the Dutch Supreme Court has to take a decision on it, and recently the Supreme Court did. And the Supreme Court said, well, given the principle of discretionary powers as we have in the Netherlands, within certain conditions, these kinds of agreements are allowed, but there is a need for a legislation. So the Supreme Court, well, was in favor of these procedural agreements, but also said, well, there is a need for legislation because it is important that the trial judge will always will take his role as he has in criminal procedure. So he is still responsible for the just outcome of the case. So this is a really new development in the Netherlands, and we have to see what the future will be. Will we go on for this development of procedural agreements, or is it just a certain tryout? And are they going to be phased out the coming years? It's difficult to say, but we're always looking in the Netherlands for new instruments for dealing with crime, because a full criminal trial, of course, is expensive and difficult. So if there are new ways of dealing with crime, then we're always trying to invent them. So to conclude for today, the public prosecutor really is dominus litis in Dutch criminal law. As we have seen, he has an important role in the investigation, always the head of the investigation. But more importantly, he is also the only authority who can start prosecution, and he has several options. He does not have to start prosecution. He does not have to go to trial. There are also several instruments for the prosecutor to handle the case without a full trial. So it's really upon the prosecutor to decide what is going, how to deal with a criminal case. So that is what I would like to tell you today. I hope it was understandable to you. It was, again, a lot of information, but I hope it was quite clear to you. And of course, I'm happy to answer your questions. Back to you, Fahida.
Okay, thank you, Prof. Prof. Yan, for your wonderful presentations. I learned a lot from your presentations, especially when you explain about the what is it? The panel order. The panel order. You know, like I just know that I knew that the public prosecutor can issue the penal order, but I just knew that it's limited. Yeah, it's not for the imprisonment, but below the imprisonment, fines, community sanctions, compensation of the victims and others. Yeah, actually, I have a question, but I will first let others to raise a questions. Maybe if you have any questions, you can raise a hand or text in the chat box if you want, or you can also ask a question in Bahasa Indonesia and I will translate it to you for you. Ada pertanyaan yang mau disampaikan kepada Prof. Yan Kranz dari banyak presentasi tadi, terutama tentang penghentian perkara, penghentian penuntutan. Itu banyak sekali macamnya. Biasanya kalau di Brawijaya itu fokusnya rechtelijk pardon. Nah, ini baru lagi nih ada namanya penal order. Nah, jadi apa namanya? Ada yang mau bertanya? Silahkan. Siapa saja? Silahkan. Bu Ika, ada nggak Bu Ika? Mau tanya nggak Bu Ika? Bunga?
Belum ada, Pak.
Oke.
No questions for today.
Mas Rudi? Rudi ada Rudi, Mas Rudi. Enggak. Okay, so this is my Angga. Okay, silakan Mas Angga.
Thank you very much, Professor. I'm so sorry I'm not clear your reason because here raining, but I'm interested your present about the real example for the prosecutor. Yeah. What would you mind giving me the real example of the prosecutor work? Maybe one example, the real example about the prosecutor in Dutch, because I know in Indonesia very complicated about the prosecutor, but I would like to know how about the prosecutor work in their professor. Okay, maybe just one question, Professor. Thank you.
Okay, thank you, Angga. If I follow him correctly, he want to ask about how the public prosecutors work in the Netherlands. You already mentioned, but in your slide, actually, but maybe because we here in Indonesia have a little knowledge on how the dominus litis works in Netherlands, you know, like the monopoly of the vervolging. Here, the public prosecutor is just a postman who deliver the dossier to the courts. I think, you know, maybe you can also stress that the public prosecutor has a power to maybe direct, to give a direction to the police, and then has the public prosecutor also works in the police office. Some of the law lecturer told them that but there are district prosecutor, public prosecutor who work in the police office, and this kind of model would the Indonesian government would like to follow, like to follow this kind of thing. Okay, maybe you can answer this, and then we have another question from Nugraha. But before Nugraha, maybe Professor Yantrens can answer Angga's questions first. Thank you.
Yeah. I'm happy to do that. I think it's quite difficult for you to understand the important role of the public prosecutor in Dutch criminal justice, because it's so different from the role of the prosecutor in Indonesia. As Faisal said, and also research in his PhD, the power is to the police, and the prosecutor in Indonesia only delivers the case from the police to the courts, and without very much involvement of the prosecutor. He's just the postman. Well, in the Netherlands, it's completely different. The prosecutor really is Dominus Litis, is really the most important person in criminal procedure. He is giving orders to the police about the investigation, and he's deciding upon prosecution. Will we go to court or will we not go to court? So he is entitled to throw away criminal cases when he thinks, well, this is not important enough, or we don't have the capacity to deal with this case. The courts are too busy. It's not that important case. We will leave the case. We will throw it away in the bin. So he actually has an important role. And of course, throwing away criminal cases, that is not the most favorable options, also not in the Netherlands. So in most cases, the public prosecutor will try to deal with the case by himself. So by giving a penal order, by giving a sanction to the accused himself. So not going to court, just say, well, you're guilty, here is your sentence, and good luck with it. And then it's upon the accused to say, well, I'm innocent, I want to go to court. But then the initiative is on the accused. So it's a really important position of the public prosecutor, because since about 20 years he is allowed, and he has the power to decide on guilt, which is an from the perspective of the trias politica and the division of powers, really, well, maybe problematic. But it is an important decision of the Dutch legislator to give the power to the public prosecutor to actually declare the prosecutor to be in a position to give decisions on guilt and to impose sanctions. So it can be difficult for you to understand, because the prosecutor really is a different different person compared to the prosecutor in Indonesia. He has a lot of powers because of this principle of discretionary powers. And then, but then I will finish. Faisal, you also said the district prosecutor who's on the police station, right? Well, in the Netherlands, the prosecutor himself is not working on the police office. He is working within the public prosecution service. But indeed, we have what we call the hulpofficier van justitie, which literally is translated as the helping prosecutor. So maybe the deputy prosecutor, and that is a policeman who is a police officer who is working on the police office, and he is working for the police, and he is a police officer, but he has certain powers that the prosecutor also has, and that is especially investigation powers. So the most simple investigation powers can be issued by all policemen. More serious are only for the hulpofficier, so for the deputy prosecutor, and the most serious investigation powers are for the public prosecutor himself, or only by authorization of the examining judge. Is that an answer to your question?
Okay, thank you, Professor.
Okay.
Thank you for your question. Thank you very much. Yeah.
Okay, next question from Nugraha.
Yeah. Thank you, Mr. Jan Kreis. I have a question about procedural agreement. It's a new regulation in Netherlands, right? It's the bargaining is it a bargaining process between the parties? Is it the same as restorative justice in Indonesia, or different? That's what I want to ask. Thank you, Mr. Jan Kreis.
Yeah, thank you very much for your question. Well, it is really new in the Netherlands, so it exactly, you say it correctly. It is an agreement between the parties. So it's between the prosecutor and the accused, but it's not an agreement between the accused and the victim. So it's not the same as restorative justice. It is an agreement between the prosecutor and the accused, and it's on the question, will we have a full trial, or do we have an agreement on important aspects of the trial, and can we enter an agreement to it so we can shorten the trial? So it's about giving up defense rights by the defense in exchange of a milder sentence by the public prosecutor. And when the court will follow this agreement, then we don't have to have a full trial. Then we can just have a short trial where the court will say, okay, I read the case file, you don't want to exercise your defense rights, and you agreed upon a certain sanction. For instance, you agreed upon 4 years of imprisonment. Well, when I've read the case file, I see that there's evidence enough, so I declare you guilty, and indeed I will give you a sanction of 4 years imprisonment. So it's an agreement between the accused and the prosecutor to shorten the trial, to give up the right to a full criminal trial, and if the court thinks the procedural agreement is indeed a good idea, then he will follow the agreement, and then he will decide according to the agreement. So that is not the same as restorative justice, because then the victim is also involved in an agreement. But I see also a question in the chat on restorative justice, so I will elaborate a bit on that also. But maybe first back to Vagisal. Was this an answer to your question? I hope so. Yeah? Okay, thank you very much. Okay.
Okay, another questions coming from Andre Octavianus. Do you want to raise your questions directly, or I can write it to you? Okay, Andre. Okay, his questions about the professionalism, how to guarantee that the public prosecutors is still professional when they dismiss the criminal cases, and then because the power, absolute power tends to corrupt, power tends to corrupt, and absolute power corrupts absolutely. I think you say that the public prosecutor has enormous power because the existence of the dominus litis. How to deal with this kind of thing to prevent public prosecutor does not abuse their enormous power.
Yeah. Very good question. Very important question as well. I should have told you a bit more about that, but I will do that now. What we have seen is that especially in the prosecution phase, there's a lot of power for the prosecutor. Your question actually is this power also under control? Is there are there means to prevent the prosecutor to abuse this broad discretion? Well, there are. Firstly, there are a lot of policy guidelines, as I told you. So when the prosecutor is not following these policy guidelines, the defendant can complain about that. So if the policy guidelines say, well, in such a minor case, you will get a penal order instead of going to trial, and despite this policy guideline, the prosecutor decides to go to trial with your case, then you can say to the court, well, what am I doing here? I have when I read the policy guidelines, I have the right to get a penal order or conditional dismissal or whatsoever. So you can always complain to the court when the prosecutor has taken a decision which violates the policy guidelines. But another example is, of course, the decision to dismiss a case. Then, of course, the accused is happy, but the victim is not. And then the victim can appeal to the Court of Appeals, and then he can say, well, the prosecutor decided to dismiss this case, so there won't be a trial. But hey, I'm the victim, and I really want the accused to be prosecuted. Well, then the Court of Appeal can say the public prosecutor must start prosecution. He must go to court with this case, and he cannot dismiss this case. So there is an option for the accused when the prosecution decision is too heavy, but there's also an option for the victim when the prosecutor has taken a decision which is too mild in light of the seriousness of the case. So yeah, there are some control mechanisms, and they are really important because this broad discretion of the prosecutor. Good question, thank you.
Okay, thank you, Prof. Yan. I want to clarify some your explanations about the guidelines or village thresholds of open bar ministry. I've just when I conduct a research on Leiden, I found that the open bar ministry village thresholds or guidelines of the public prosecutor connected with the court decisions. Is it always the case that when the public prosecutor want to issue, or the board of the Procurator General issue the village thresholds or the guidelines, they need to always consider the judicial decisions? Because when I read the Belisreichels on the how the public prosecutor should prosecute the theft, for instance. I read that they connected their regulations with some judicial decision or court decisions in some places. Is it always the case, or it's only the one of the or two examples?
Yeah.
Okay.
Good question. Well, the policy guidelines of the public prosecution service are developed by the Board of Procurators General. That is true, and of course, they will partly be based upon the sentencing decisions of the court. And the courts in the Netherlands also have orientation guidelines for their own sentencing. So there are also some guidelines for the courts themselves. But guidelines for courts are a bit difficult things because the judge is independent. So we call it orientation guidelines. It's a starting point for the court when when they are thinking about sentencing. But your question is, do the policy guidelines are they inspired by court decisions? The answer is yes, of course, but the main practice in the Netherlands is that courts are almost always sentenced a bit lower than the prosecutor demands. So the prosecutor will say, well, in this case, I really would like a sentence of 4 years imprisonment, but they're asking for 4 years because they know that the court will say, well, 3.5 is enough. So also in these policy guidelines of the prosecution service, they're always a bit higher than the orientation points of the courts or the sentencing decisions of the court, because they know the court will give a certain discount. And that's why the policy guidelines are a bit more severe than the court decisions are. Is that an answer to your question?
Yes.
Yeah. Okay.
Answer perfectly.
Okay.
Okay.
And about restorative justice in the chat, I will elaborate a bit more on restorative justice also in the fourth lecture. But there are options on restorative justice actually in every phase of the criminal proceedings. So in the prosecution phase, but also in the trial phase. But restorative justice is important in the Netherlands, but still practice is difficult. So we're trying to introduce restorative justice, but we're not very successful yet. So that's all. That's already a teaser for the fourth lecture.
Okay. Thank you. Because Indonesian government oblige each criminal justice actors to apply the restorative justice. Now we have many regulations on restorative justice issued by each criminal justice actor. The police has their own policies on the restorative justice, and it's not synchronous with the public prosecutor also on the judge. It's very complicated practice here also in Indonesia.
Yeah.
Okay, I have one more question if you don't mind.
No, go ahead.
The conditional dismissal or forwaardelijk SEPO. What is the difference between the SEPO and forwaardelijk SEPO? Forwaardelijk SEPO is I think it's very different with the strafbeschikking, right?
So again, it's about the difference between the conditional dismissal and the transactie?
No. Conditional dismissal and unconditional dismissal. Because the Minister of Justice also can, can ask the open bar ministry to dismiss a case, right?
The Minister of Justice.
Minister of Justice.
Yeah, but that doesn't actually happen in the Netherlands. It is possible. It is possible that the Minister of Justice will intervene and say to the prosecutor, "Well, I really would like you to dismiss this case," but that does not happen in practice in the Netherlands.
Yeah, because here in Indonesia we have a debate on this because we call the SEPO is deponering, not seponering, but
deponeer, yeah.
Deponeer, not seponeer. Do you know? Do you also have the similar? Deponeer is seponeer or is different? Because one of my colleague insists that the deponeer is like the Minister of Justice power to ask the prosecutor to dismiss a case. It's different with SEPO. Depo and SEPO is very different.
Yeah, it's different. It's different because it's this SEPO, this unconditional dismissal, is really a decision by the prosecutor himself, without any involvement of the Minister of Justice. It's just in minor cases the prosecutor say, "Well, I don't have time. Let's drop the case." So it's without involvement of the Minister of Justice. And in the Wet RO, in the Act on the Judiciary, there is a possibility for the Minister of Justice to intervene in individual cases. He may say, "Well, you should drop this case or you should go to court with this case," but it does not happen in the Netherlands because we don't want the minister to intervene in individual cases. So there is a possibility, but it's not used in practice. The involvement of the minister is really on criminal policy. So he is intervening in guidelines, of course. We can say, well, the guidelines on theft, they must really be higher, and that is what the minister may say and does say in the Netherlands, but he will not intervene in individual cases. So there is the difference between the unconditional dismissal and deponering in Indonesia.
Okay, so deponer is for the minister, right?
Yeah.
Okay. Yeah. Okay. Do you have another questions, students? The last question before we close, and we will meet again next week. Still with Prof. Ian Crimes, but the moderator is not me anymore. Mrs. Fines will be a moderator for next week.
Yes, but on next week, I think it is within 2 weeks, right? November 24. Yeah.
24 November. Yeah. Okay.
So not yet. Yeah. Then I see you within 2 weeks. Thank you very much, Dr.
Okay, but I will follow your lecture. Don't worry, I will follow your lecture because I want to learn more about this kind of thing. Do you have other questions? No, students or maybe participants from outside Brawijaya University. If you also join in this lecture, you can also raise questions. Okay.
Thank you.
Your explanation is very clear. Then I hope I can see you next week. Okay.
Thank you very much. Thank you for the great questions, and have a good weekend.
Yes, you too.
Bye bye.
Bye bye.
Thank you, Professor.
You're welcome. See you within 2 weeks. Bye bye.
Bye.